All right, welcome to the 294th District Court. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Daniel McGregor. Emerson Abbott. Here. Randy Chavez Torres. Sean Davis. Here. Hannah Hampton.
Judge, I received a message from Ms. Hampton. I believe she's in the hospital.
Timothy Hubbard, the custody in Henderson County, and we'll be doing a Zoom hearing, I believe, at 9:30 in the state room. Dennis Ray Jones. All right, not associated with these cases, is that correct?
Correct.
All right. Court's going to find Mr. Jones's bond to be insufficient at this time. Christopher Mobbs. Here. Kenneth Nash. Here. John Pease. Here. Timothy Richardson. Patrick Rowe. Randy Session. Christopher Slow, CR 24-149 or Slew. We show that he's verified in custody in Dallas County. We'll recall his case. Sarah Walker. Corey Kimble. Here. Curtis Smith. Here. Jesse Ryan St. John. Here. Mark Lemon. Here. Delvin Mitchell. Here. All right, is there anyone's name who's not been called? Your name, sir? Joshua what? Morgan. Morgan? Let's see. Probation. Yeah, all right, I got you, Mr. Morgan. All right, we have anyone that's ready, counsel? Who would you like to call first, Mr. White?
Could we call Mr. Mitchell?
Delvin Mitchell, if you'll come forward, please. This is cause number CR 24-103, State of Texas versus Delvin D. Mitchell for pretrial. Go ahead, Mr. White.
Your Honor, as court's noted, we're set for pretrial. I have a small discovery issue on this. Ms. Salzman, my paralegal, and Ms. Abney over at the DA's office are working on getting that resolved. I've seen everything, but there was, I think, some sort of formatting issue with a in-car video. I need to look at that, and then I think we'll be able to make a decision on how.
All right. Any objection from the state to
No
continuing trial?
No objection, Your Honor. Thank you.
I believe we've got some stuff set on November 12th. Is that a date okay with the court? We get there.
Yeah, that's fine. All right, court will set Mr. Mitchell then November 12th. It's a Tuesday at 9 a.m. What's the date?
Oh, 11, 12.
Mr. Mitchell, free to go.
Free to go. Who'd you like next?
I believe I only have Mr.
Mark Lemon. CR 15-463. Motion to adjudicate. Go ahead, Mr. White.
Your Honor, we're set for a motion, obviously set for a motion to case. I am attempting to get some additional information by the state on Mr. Lemon. I believe if we could move this to November 12th docket. We will have an answer for the court at that point as to whether or not we're going to accept a plea agreement or whether or not we're going to proceed on the contested. If we got to proceed on the contested, I would anticipate, given the kind of the amount of time between now and then, I would be ready probably fairly soon.
Okay, my plan was to set you November 12th, and today go ahead and set you for the contested docket on November 26th.
That'll work, yes, sir. I couldn't remember what the date was, but
Yeah, it's the 26th. It'd be 2 days before Thanksgiving. Any objection from the state?
No objection, Your Honor. Thank
All
you.
right, court sets Mr. Lemon for additional hearing on motion to adjudicate November 12th and sets it for the contested docket on the 26th, should a resolution not be reached sooner. And once he gets his notice of appearance, he's free to go.
Thank you.
Mr. Wright, you ready?
I'm kind of like, got to plea that I've got to go over that, that's it. Get done right now.
Who would you like to call first?
Corey Kimble.
Corey Kimble, CR 24142 for pretrial.
That's correct, Your Honor. I have already filed my normal motions that I don't believe there's any opposition to the state. There was one thing that I was wanting to ask and not able to get it because as Ms. Curry's actually the one handling this case right now, and I probably should have asked earlier. But the videos that I have do not show any arrest video. And I was wanting to inquire to see if there was actually that because of the possibility of statements that could have been made. And I was asking for another pretrial.
And Your Honor, we'll get with the agencies and see if there is an arrest video, and if there is, then we'll make sure to get that to Mr. White as soon as possible.
All right, Mr. White, would you like to set this on Thursday, November 14th?
That sounds good to me, Your Honor.
All right, court sets Mr. Kimball for pretrial November 14th at 9 a.m. And Mr. Kimball, have you signed your conditions of pretrial release yet? Have you met with the pretrial release officer, Mr. West? All right. Once you sign your notice, you're free to go.
And Your Honor, the next one, Curtis Smith.
Mr. Smith, if you'll come forward, CR 24-64 and 65, State versus Curtis Wayne Smith for docket call.
Yes, Your Honor, we'd like to set this for a plea in about 2 weeks, maybe.
You can come back on October 17th.
Let me check. I believe we could do that.
All right, afternoon or morning?
Morning.
All right, court sets Mr. Smith for plea before the court October 17th at 9 a.m.
Hold on. Got to. Yeah, right there. And Your Honor, I do have another plea, but I haven't gotten
Free
the
to go.
paperwork.
You're free to go.
You're free to go. And I'll be back with you in a little bit.
That's fine. Mr. Morgan. All right, this is cause number CR 22-309, State of Texas versus Joshua David Morgan. And Mr. Morgan, you're here today asking the court to extend your period of probation for an additional 1 year. Is that correct?
Yes, sir.
And why are you asking for it to be extended further?
I still need to take a class. I found where I could do it on Zoom. I already took it. I was down to 2 classes. And you only miss 3 times. So I'm trying to work a full-time job and get there before. So I found where I can take it on Zoom. I just gotta save the money, take it on Zoom, and finish paying the fines related to that. That's why I need that extension.
Okay. And you believe if I extend it today, that would enable you to successfully complete all of your conditions?
Yes, sir. On the community service, I'm trying to see if I can do it in Athens, because I live in Payne Springs. I also live in Van Zandt County, so I'm trying to see if I can do it down there. It'd be closer to each committee to get more of it done. I don't know if it's possible. I don't know how that works. I'm trying to find out.
All right, I'll let you talk with your probation officers to figure that out. All right, court's going to amend the conditions of community supervision for Mr. Morgan. Court's going to extend his period for an additional 1 year. Your new expiration date will be October 12th, 2025. And the court finds that there's a request to waive the probation fees and your analysis fees by the probation department, so the court does approve that. All right, so Mr. Morgan, come back here, meet with Ms. Burns. You can get a copy of this, and then you're free to go. And when Mr. Morgan leaves, he'll leave out the back over here. So if you're with him, you can just have a seat in the hallway. He'll be out shortly. Daniel McGregor. All right, Mr. McGregor, this is cause number CR 24172. And we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my car. And right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review, so currently I'm waiting for that to.
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs and I've got a few interviews scheduled as well, so
When are your interviews scheduled?
today and this weekend or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have 0 expenses. Because didn't you say you live with your father or something? Do you live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
But $1,300 doesn't help me get 10,000.
It doesn't?
No,
It helps you. It would help me get 10,000 because that's $1,300 towards that 10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels, so that didn't last very long because I asked them questions about their policy and they said that it wasn't working out. So,
How much are you paying your bondsman?
paying what?
How much are you paying your bondsman?
The bondsman, I paid 5,000 total. But that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away and I was driving too far. So I've been kind of up and down with jobs, like I've had 3 jobs the past year and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm gonna reset you for 2 weeks. Reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses and you come back without a lawyer, we're gonna have a hearing on your bond. I may find your bond insufficient that day, and I may put you back in jail. And the longer you sit in jail, more likely you're gonna become indigent to the point where I can appoint you an attorney. You see how that works? You're gonna pay your bondsman $5,000. You're gonna have a job, you're gonna pay them $5,000 and you're gonna get out of jail, but you're not gonna hire an attorney to go forward on your case.
I would hire an attorney if I had 10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you've got a car, so you can drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks. If you don't have a lawyer in 2 weeks, then we're gonna discuss your bond that day. Bring him back in here when you get a chance, Fabio. Oh, yeah, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. You understand that?
I accidentally tried to overstep the wrong way. I apologize.
I'm gonna find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm gonna appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm gonna up your bail to $150,000, and I'm gonna appoint you an attorney.
150,000.
Yeah, so it said 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of your sexual assault of a child charge that you have? Do you want that? Yes or no? No? Okay,
I apologize.
it's okay. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right, go ahead and take him and I'll send over an order. believe Mr. Manning has the rest of the cases. All right, court's going to stand in recess so Mr. Manning can meet with his clients. So I'm just going to stand in recess until Mr. Manning says that he's got enough ready to make an announcement. So whenever that is, we'll be back. Okay. So you do not have to stay in the courtroom. You can move about. Just make sure that you check in. Most of you are here with Mr. Manning, correct? All of you? All right. So just make sure that you're in and around Mr. Manning so he can tell you when it's time to be back in court. Okay. All right. We're in recess.
Yes, Judge.
Who would you like to call first?
Judge, we will be having two pleas. They're still finalizing the paperwork in the clerk's office. So if we can go through and do the resets now, that'd be great.
Yeah.
We can start with Mr. Emerson Abbott.
Emerson Abbott, CR 2488. All right, Mr. Emmett, or I'm sorry, Mr. Emerson Abbott is set for docket call.
Yes, Judge. Mr. Abbott and I have had an opportunity to go over the discovery as well as discuss the plea offer that's been extended by the state. In talking to Mr. Abbott today, he is asking for an additional 30 days to consider the offer. We had some additional discussion based off of our prior meeting, and he'd like additional docket call to make his final decision on that offer.
Any objection from the state?
No objection to a final docket call, Your Honor.
All right. Mr. Manning, you want to set November 14th?
Judge, I believe. Let me check my vacation letter.
Cut you off on the 12th. The 4th through the 12th.
Yes, Judge, I will be back on the 14th. That'd be fine.
All right, court sets Mr. Abbott for a final docket call November 14th at 9 a.m.
And Judge, I have explained to Mr. Abbott that if he chooses to reject the offer, that the court will not entertain or may not entertain any additional plea offers or resolutions other than a dismissal or trial.
Thank you, Mr. Manning.
May he be excused.
Yeah, it's pretty good.
Judge, next ready on Mr. Chavez Torres.
Randy Chavez Torres, CR 24-46. Show that Mr. Chavez is set for arraignment.
Yes, Judge. Judge, Mr. Chavez Torres' name is spelled correctly. He understands the charge against him as well as a range of punishment and would plead not guilty and request to be set on the pretrial docket.
All right, court finds that Mr. Chavez has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record and sets this matter for pretrial on November 14th.
May he be excused.
There you go.
Judge, next ready on Mr. Sean Davis.
Mr. Davis, if you'll come forward, cause number CR 23-95, CR 23-207, CR 23-208, CR 23-209. We're set for status on defense expert, is that correct?
Yes, Judge. Mr. Davis has been able to procure the cost from one of our experts. However, due to some car repairs and some emergencies, he's been able to secure the large financial commitment for the second. I would ask, I think we've got a situation where he's gonna be able to be putting money towards that now that he got his car fixed. I'd ask for additional reset for the second expert to be able to do the first, now that he saved the money, do the first expert and then save the money for the second.
Date's position.
No objection, Your Honor.
All right, 30, if we set it November 14th, is that sufficient?
That should work, Judge.
All right, court sets Mr. Davis for additional pretrial status of defense expert for November 14th in all causes at 9 a.m.
Did you say November 14th, correct?
Yes.
May be excused.
Yeah, free to go.
Judge, what we'd like to do on, I'm sorry, I did not provide that to Miss Tabraham, on Miss Hampton.
Ms. Abraham's indicated that Ms. Hampton's already preset for October 31st on contested evidentiary docket.
Yes, Judge.
Today was going to be a status,
Yes, Judge.
but if you'll go ahead and provide that information to Ms. Hampton, court will not take any action against the bond today. It finds that she is already set October 31st.
Thank you, Judge. I am sending that to Miss Tabraham right now. What about Mr. Hubbard?
And that was on cause number CR 20-390. We have not seen Mr. Hubbard in Henderson County. You better call him.
Judge, if you'd like, we could,
Try it tomorrow. Try it for this afternoon. We'll just try to make it work.
yes, Judge.
We'll just recall it this afternoon at 1:30.
Judge, next ready on Mr. Christopher Mobbs.
Mr. Mobbs, if you'll come forward, cause number CR 24-104, say versus Christopher Perez Mobbs, pretrial.
Judge, we've had an opportunity to review the discovery in this case. We have no contested pretrial issues at this time and request to be set on the docket call.
Court sets Mr. Mobbs for docket call November 14th at 9 a.m.
May he be excused.
Yes, great.
Next ready on Mr. Nash.
Kenneth Ray Nash, CR 22-71, pretrial.
Judge, at this time, we have no contested pretrial in Mr. Nash's case. We request to be set on the docket call announcement.
Court sets Mr. Nash for docket call November 14th at 9 a.m. Mr. Manning, I show that Mr. Nash is delinquent on his pretrial supervision fees, $230.
Judge, I'll speak to Mr. Nash and see if he can make a payment today.
Mr. Nash, can you make a payment today?
Yes, sir. I paid here this morning. I paid ahead this morning, and I will pay up over when I go there this morning after.
What are you paying here?
I paid the court fees and stuff that I had.
What court fees do you have?
I had the I don't know, they were like, it's like $25 a month or
Is it a different case?
no.
Well, you shouldn't be paying anything across the hall because court granted your motion for new trial, so you don't owe anything because that previous judgment was withdrawn.
Okay,
So the only fees that you have now are going to be with the pretrial release department.
yes, sir. I have a receipt to show you that I paid, and maybe you can you know what it was.
I'll speak to him about
Mr.
that.
Manning look into that, but before you give them any more money, let Mr. Manning figure out if it's related to this, should be related to this. Yes, sir.
Yes, sir. I'll figure it out. Wait, no, hold on. Judge, once we figure out that payment issue, may he be.
Yes.
Judge, we're gonna have a plea on Mr. Peace and Mr. Richardson. And if we can call Mr. Rowe.
Patrick Ray Rowe, CR 23-116. And clause number CR 23-117. Mr. Rose said on docket call in each case.
Yes, Judge. I just received a message. Miss Curry is the one that's handling these cases, and I just received a message from her that I think concludes the questions that she and I have been going back and forth on. If I may have one additional docket call to speak with my client and make sure that we're all set, I think we'll be ready to proceed to jury selection after the next docket call.
You want to reset it for a couple of weeks, like October 17th? Does that give you enough time?
Yes, Judge, I believe that would.
All right, Mr. Rowe, ordered back October 17th at 9 a.m.
May he be excused.
Free to go. Well, I do show, Mr. Rowe, I do show you're delinquent on pretrial release fees by $60. Can you pay that today? All right, go. Ordering you to pay that.
Thanks. Next, Judge, ready on Mr. Sessions.
Randy Session, CR 24-177, CR 24-178. All right, so that Mr. Session is set for arraignment in each case.
Yes, Judge. Mr. Sessions' name is spelled correctly. He understands the charge against him as well as the range of punishment, and he pleads not guilty to both charges.
All right, court enters Mr. Sessions' plea of not guilty to each indictment in each case. Court that he's waived the formal requirements of arraignment. Court sets Mr. Session for pretrial hearing on November 14th at 9 a.m.
May he be excused.
Yes, here you go.
And Judge, just for record purposes, Mr. Sessions informed me that he had his meeting at 10:30.
10:30.
At 10:30 to meet with his pretrial release officer. I explained to him that as he was under the court order of the court to be here, that he would have to be a little bit late to that meeting. So I just want, for record purposes, he did acknowledge he did have that meeting at 10:30, and he's headed over there right now.
It's with Simmons.
Okay, you're fine.
Okay, thank you. Judge, next ready on Miss Sarah Walker.
Do you have any update?
Yes, Judge. I'll make that announcement.
This is cause number CR 24-190, State of Texas versus Sarah Rhiannon Shaddix Walker.
Judge, I was able to speak to the county court law judge, Judge Winters, and he does not oppose the cases being transferred up, nor does he oppose that warrant being withdrawn. He said that he was not concerned either way with how that paperwork's done, if we want to transfer it first and then you withdraw those warrants, or if we want to withdraw the warrants and then transfer them. I spoke to Ms. Tabraham, and due to some technical issues with the Van Zandt County system, she was unable to print out any paperwork. So if the court would indulge, when I get back to the office, I can print or try to get a withdrawal of warrants and motion to transfer all done at the same time.
Okay, that's fine.
Additionally, Judge, I have gone over the indictment with Ms. Walker. She She understands the charge against her. Her name is spelled correctly. And at this time, she's pleading not guilty and requests to be set on the pretrial docket.
All right, the court enters Ms. Walker's plea of not guilty. And the record on this charge finds that she's waived the formal requirements of arraignment. Court sets Ms. Walker for pretrial hearing on November 14th at 9 a.m. The court will grant a motion to withdraw the warrant. So just understand, Ms. Walker, that there will be warrants active for you when you walk out. So should you be stopped, traffic or some other way, there's the likelihood that you'd be taken in on those until Mr. Manning's had time to get the motion filed, and I've had a chance to sign it, send it out to the sheriff's office. So you need to be aware of that.
Judge, would you like for me to go ahead and set those misdemeanor cases?
Yes, sir. What's those numbers?
We have 2024 dash 00138, 139, and 140.
All right, and upon the motion, the court will grant the motion to transfer subject to Judge Winter's signature on that motion as the referring judge. And then the court will go ahead and set, anticipating that it will be approved. The court sets cause numbers 2024, 138, 139, and 140, also on November 14th and 9 a.m.
Thank you, Judge. May she be excused.
Free to go.
Thank you.
Need time to go over your plea papers.
Judge, they're just being tendered to the state for their signature. Everything else has been signed and sworn to.
All right, the court calls cause number CR 24-149, State versus Christopher Paul Slew. Court finds that Mr. Slew is currently confined in the Dallas County Jail. Here's that he was arrested, a probation violation, aggravated assault, deadly weapon, and also failure to comply with sex offenders' duty to register. A probation violation for assault. And online solicitation of a minor. Here's, he may also have a blue warrant. So at this time, the court's going to find that Mr. Slew's bond, if any, is insufficient. Will request a detainer be placed upon him, and we will reset this for status on November 14th. Yes, sir.
Judge, yes, we spoke to Mr. Delhambre, I believe.
State, do you want to come up there? John David Pease. This is cause number CR 24-106, State versus John David Pease. Mr. Pease, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Do you have difficulty hearing?
Definitely, sir.
Okay. I'll tell you what, Mr. Manning, why don't y'all come on up here? Does this help? Okay. All right, Mr. Pease, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you? Do you have any questions about any of the paperwork you've signed today or anything about your plea agreement? No. Mr. Manning, do you believe Mr. Pease to be competent?
I do, Judge. I would state, Mr. Peace, does have some injuries from the old football days, that, do affect his ability to remember, and to, process certain information. I've ensured a particular amount of time, both today and in my meetings with him, to just get that little extra time. He is able to understand. He's not dumb. He's not stupid. He's not crazy. It's just because of those injuries, it takes him a little bit longer to get that sunk in. And the paperwork does help that he can have those reminders. So I do believe he is competent. It's just a little extra work needed to make sure he gets all his questions answered and comprehend what's going on.
Okay. All right, Mr. Pease, you are charged by indictment with a third-degree felony offense of continuous violence against the family. I see today, though, that you are asking the court to plead to a lesser offense as recommended by the DA's office to a assault causes bodily injury of a family member, that being a Class A misdemeanor, which would carry a range of punishment of not more than 365 days or a fine more than $4,000. I see the plea agreement is upon your plea of guilty, the state's recommending that you be convicted of this offense, that your punishment be assessed at the maximum 365 days or 1 year in the county jail, but that the sentence be suspended and that you be placed on probation or community supervision for 2 years, along with a $500 fine, court cost of $270, and reimbursement fees to Van Zandt County of $535. And as a special condition of community supervision, it appears that you would be required to enroll in AA. Is that your understanding of the plea agreement?
Yes.
That's what you're asking the court to approve? All right, understanding the range of punishment, understanding the plea agreement, Mr. Pease, how do you plead to assault causes bodily injury of a family member? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection. The state's one has offered.
All right, stipulation of evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that Ms. Cheney did reach out to the victim, in this case, Ms. Moran, and she is very supportive of the reduction in the charge and the plea agreement as offered to the court.
Thank you, Mr. Hartwell. Anything further from the defense?
Rest of closed, Judge.
All right, the court does review the stipulation at this time. All right, court finding that there is sufficient evidence to convict the defendant, the court will follow the plea agreement and the recommendation by the DA's office. The court hereby convicts John David Pease of the lesser included offense, Class A misdemeanor, assault causes bodily injury of a family member, assesses punishment at 1 year confinement in the county jail. The court suspends that sentence today, places Mr. Pease on 2 years community supervision, orders him to pay a $500 fine, $270 court cost, $535 in reimbursement fees, and as a special condition of community supervision that he enroll in the AA program and successfully complete the AA program.
see that.
All right, Mr. Pease, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. After you are fingerprinted here by Deputy Martinez, then you will meet with the probation officers and they will give you more information about what's next. Mr. Richardson, so you're already up there. I was going to tell you to approach, but you already did. All right, this is cause number CR 24-187. State of Texas versus Timothy Lance Richardson. Mr. Richardson, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. All right, Mr. Richardson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you feel like you understand everything that you've read and signed today that's part of your plea agreement?
Yes, sir.
Do you have any questions before we go further?
No, sir.
Mr. Manning, do you believe Mr. Richardson to be competent? And if so, have you explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge, I have explained his rights and the waivers therein. Additionally, Judge, I've explained the advantages and disadvantages of taking an offer that includes deferred probation. He understands the pros and cons of that and is willing to proceed intentionally, knowingly, and voluntarily.
Thank you. All right, Mr. Richardson, you are charged with a state jail felony offense of publishing intimate visual material. That is a state jail felony, and it does carry a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case is that you would be pleading guilty to that crime. The state's recommending that the court consider the evidence but not convict you and place you on 5 years community supervision with a $2,000 fine, $290 in court costs, and the state is agreeing to resolve several unfiled cases: a possession of marijuana less than 2 ounces, a possession of child pornography, and also as a condition of community supervision, you would have a sex offender evaluation, and there would be no contact with the victim throughout your entirety of your community supervision. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, Mr. Richardson, how do you plead to publishing intimate visual material?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the admission of the stipulation of evidence?
No objection. States one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I believe the court has received the victim impact statement in this case. Additionally, it's my understanding that the victim in this case is hesitantly supportive of this plea. The biggest part of the agreement is that no contact order. And I do just want to reiterate that no contact means absolutely no contact as a condition of probation. That a single violation, the state will be filing an MTA and seeking prison time.
Thank you, Mr. Hartwell. Court's going to review the victim impact statement at this time. All right, anything further from the defense?
That's all those.
All right, for the record, the court has signed the victim impact track. All right, then court is going to consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict Mr. Richardson of this offense. Court will follow the plea agreement and the recommendation of the DA's office. Court hereby defers a finding of guilt on the state jail felony offense of publishing intimate visual material. The court places Mr. Richardson on 5 years community supervision, orders him to pay a $2,000 fine, orders that he undergo a sex offender evaluation, and that he shall have no contact with the victim in this matter. Additionally, the court will dismiss under section 1245 of possession of marijuana less than 2 ounces and a possession of child pornography unfiled DA 2024-694. Court orders him to pay court costs of $290 and reimbursement fees of $535. Mr. Richardson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted on your judgment. After that, you'll meet with the probation officers over here. Yes. Is that all you have, Mr. Manning? Is that all you have this morning?
I believe so, Judge. Be excused.
Yes, you're excused. Mr. White, are you ready with Mr. St. John? St. John, go come forward.
And Your Honor, may I approach?
Yes, please. Thanks, sir. Court calls cause number CR 24-00036, State of Texas versus Jesse Ryan St. John. Mr. St. John, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, thank you. You can lower your hand. All right, Mr. St. John, are you a United States citizen who reads, writes, and speaks English? Yes, sir. And have you ever been diagnosed with a mental condition? No, sir. In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White and the work he's done for you? Yes, sir. Do you have any questions about your plea papers or anything that you signed? No, sir. You ready to proceed? Yes, sir. Mr. White, do you believe Mr. St. John to be competent? And if so, have you explained to him his rights regarding this case and also the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor. He's competent to make the decisions. He knows that if he winds up getting this probation completed, this in effect becomes a not guilty on the record with only an arrest being present. He also knows that even as simple as another speeding ticket could result in a 10-year sentence.
Thank you, Mr. White. All right, Mr. St. John, you are charged with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a punishment range of not less than 2 years in prison or more than 10 years in prison, and also a possible fine not to exceed $10,000. I see that the plea agreement is that you would be pleading guilty to that crime, and the DA's office is recommending that the court consider your plea and the evidence, but that the court not convict you today, but rather place you on community supervision for 6 years, including a $2,500 fine and defensive driving as a condition of your community supervision. In addition to that, you would also have court costs of $290 and reimbursement fees of $35. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, Mr. St. John, how do you plead to evading arrest or detention with a vehicle?
Plead guilty.
You're hesitant. Is there a reason you're hesitant?
I'm just nervous.
Okay, that's okay.
Yes, sir. It's cold in here.
All
I'm
right.
sorry.
It's okay. Nothing to be,
This is
I
my
mean,
first time.
I understand it's a
Yes,
very
sir.
formal proceeding, but there's nothing to be nervous about. I just need to make sure that you're of sound mind today and that you're not allowing your emotions to cloud your judgment or anything like that. So I understand being nervous, but you've had some time to talk with Mr. White regarding your case. You've gone off over this paperwork. You understand what you're doing today, correct?
Sir.
Okay. And so you're telling me that you are guilty of committing evading arrest or detention from the vehicle. Is that right? And Mr. St. John, has anyone threatened you, forced you, or made you plead guilty here today?
No, sir.
All right, then the court will accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
That's what, Your Honor.
All right, court will consider the evidence. All right, court, having considered the evidence, finds that there is enough evidence to convict the defendant of the offense. The court will follow the recommendation of the DA's office. Court defers a finding of guilt on the third-degree felony offense of evading arrest or detention with a vehicle. The court orders Mr. St. John on 6 years of community supervision, orders him to pay a $2,500 fine, $290 court costs, and $35 in reimbursement fees. Court also orders him to complete defensive driving as a condition of community supervision. Mr. St. John, how old are you?
I just turned 20.
Just turned 20.
Yes, sir.
And so reading the evidence in here, it says that you were traveling over 100 miles an hour when a state trooper saw you and turned around on you to make a traffic stop, and then you took off. And then ultimately he caught back up with you or came into contact with you, and that's when you were arrested. Is that right? Roughly?
Yes, sir.
Okay. And so what you were looking at was a Class C ticket of a fine only, no jail time, no prison. Fine only, max $500. And instead you made a decision to elude or evade the police officers, which then made your Class C offense a third-degree felony offense. Do you understand that the decisions that you make have consequences, and those consequences can elevate the conduct? You understand that? And so as a 20-year-old young man, you have 6 years of felony community supervision hanging over your head now, when if you would have just followed the law and stopped and gotten your traffic ticket, you could have paid that off, taken defensive driving, possibly even kept it off your record. But the decision you made has now complicated your life to a large degree. You understand that? Now, all of those it was a bad decision, and you are suffering a bad consequence because of it. However, I can see the positive in this. It's because had the trooper not been there that night, who knows, driving at that speed, if you would have lost control of your car and killed yourself or killed someone else on the road. You're very fortunate that even though you went from a Class C ticket to a third-degree felony, you didn't kill anybody. And you don't have to live with that for the rest of your life. And you don't have to face possible prosecution of up to 20 years in prison for taking someone's life. So there's a silver lining that can come out of this if you choose to view it that way. And so I hope that the next time you have a choice to make a decision, that you think about the decision you made back in July of 2023 and start thinking through what the consequences of those decisions that you make every day. So you're going to have decisions that come across, that you have to decide, are you going to comply with this probation? And I hope that you make the right decision, because if you don't, you make another poor decision, you could end up right back in here. And I'm going to have, if it's proven to me that you make a bad decision and you violate these terms, I'm going to have to do my job. And I'm going to have to revoke your community supervision. And when I do that, I can do several things, including putting you in prison anywhere from 2 years to 10 years. I don't want to do that. And so I don't want you to put me in the position, put them in the position that they have to file, and me in the position that I have to do something. You understand?
Yes, sir.
All right. So let's chalk this up to a very poor decision, wherein you've been given a second chance through the work of Mr. White and what these prosecutors are giving you the opportunity to do. And that's to have this put behind you, albeit at a bigger cost to you, but an opportunity to put it behind you. And it can be a youthful indiscretion. Make sense?
Yes, sir.
Okay. All right. So I expect you to be one of your probation officer's favorite probationers. I expect when you walk in that they know that you are doing everything that you're supposed to do, and that it's a 5-minute check in, check out. That's what I want for you. You understand?
Yes, sir.
All right, Mr. St. John, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward. Deputy Martinez is going to take your fingerprint on the judgment. After that, you'll meet with the probation officers.
That's all I have.
Do you have anything this afternoon?
Unfortunately not.
Okay, well, we'll see if we can drum up something to call you.
Thank you, Judge.
Have a good day. Appreciate it, Mr. White. All right, so we're going to recall Mr. Hubbard at 1:30. We don't do it. We're going to recall Mr. Hubbard at 1:30. What did we say about Mr. Jones? Oh, and he's in our custody. That's right. Okay. So we're going to recall Mr. Jones at 1:30 also. And the court has or it will be finding his bond insufficient on this charge. And I believe that concludes this morning's criminal docket. All right. All right, court's going to stand in recess until 1:30.